Welcome to Discovering the Law. My name is Lucy Rivera and I am the host today. This episode can be viewed at www.discoveringthelaw.com. Today, we are honored to have a very special guest from the Massachusetts Supreme Judicial Court, Honorable Justice Geraldine Hines.
It's my privilege and my honor to be here.
Justice Hines, thank you for your time.
Of course.
Justice Hines, please tell us about the Massachusetts Supreme Judicial Court. What is it?
Okay. It is the oldest appellate court in the Western Hemisphere. Our court was started in 1692. It's 324 years old, and it stands out for many people as an example of what an appellate court should do. We only deal with appellate issues. Our court system has other divisions that deal with trials. Our Superior Court deals with major criminal cases and major civil cases. We have a district court that deals with some misdemeanors and what we call concurrent jurisdiction felonies. We have a family court. We have a housing court, a land court, and a juvenile court. So all of the people's business gets done in one of those courts or another. And if anybody is unhappy with the way the case turns out at the trial level, they have an opportunity to appeal to our court or to the appeals court, which is our intermediate appellate court.
And how does the Supreme Judicial Court operate with, in terms of how many justices are there?
We have 7 justices, 6 associate justices, and a chief justice, first among equals, as he would say. And we decide about 200 cases a year. The 7 of us, we sit the first week in every month for that week, and we hear probably 20 to 25 cases each month. We sit from September to May, and the justices write about 200 decisions a year. Each one of us writes about 24 decisions, and we sit in panels of 7, except on the day when the court hears murder cases. Only 5 justices sit on the murder cases. And that's because the justices who have been single justice, and I can explain that if you like, don't sit on a murder case the month that they're single justice and the month after they're single justice. Now, each one of us has to take a turn being single justice, and that just means that we're the designated justice for that month to consider a whole range of things that may come in on an emergency basis. We may get appeals of bails that have been set in the Superior Court. We hear bar discipline matters. We hear appeals from decisions that have been made in the trial court. Some of those decisions are open to us to review them at that stage, although typically we don't hear issues until the case is resolved. So our job is basically to let the cases run their course in the trial court, and if there is an error of law in the case, we have the authority, depending on what kind of case it is, to hear those cases and to make a decision about whether an error occurred or not. Typically, however, the appeals court is more of an error correction court. The kinds of cases that we get are cases that we have chosen. We choose our own cases, with the exception of certain classes of cases. All first-degree murder cases are heard by the SJC, and we choose the other kinds of cases that we're going to hear. And usually that's because it's a case of first impression. That issue is open, it's unresolved, and it needs to be resolved by our court. I can give you an example of that. I think it was last year, there were cities and towns all across the Commonwealth that were adopting ordinances that would keep registered sex offenders out of their towns. And so we took that case because the law at that point was not very clear, and it's an important issue. And we thought that the resolution of that issue should come from the highest court. And so we took that case and resolved it. And that's typically how we decide on cases. It's important. It may be complicated. There's no clear solution to the issue, and it needs to be resolved by our court.
Out of the 7 justices who sit on a given hearing, how do they decide an issue, particular issue of first impression where there is no resolution prior?
Right. Well, we have briefs from the parties, and if it's an issue that has sort of broad interest or broad appeal, we put out a call for amicus briefs, and frequently we do get briefs from organizations that are working on a particular issue. In criminal cases, we frequently get briefs from the Innocence Project or the Committee for Public Counsel Services. And so we depend a lot on the lawyers to educate us, because we don't know everything about everything. Sometimes we don't know anything about the issue that comes before us. And so we rely on the lawyers to educate us in their briefs, or the amicus briefs will generally give us a picture of how a particular issue will affect people more broadly. The parties in the case are going to be dealing mostly with how the decision would affect those parties, but we rely quite heavily on amicus briefs to help us understand how our decision will have an impact in the community, in the Commonwealth, and that's something that we always want to know. I mean, our decisions aren't necessarily driven by concerns about how it will play, but we do want to know that when we're making decisions about how statutes ought to be interpreted, or contracts, or issues in criminal cases, that sort of thing.
Would you be able to comment as to the balance of where do justices lean as to the different issues? There are 7,
right? An
odd number, and in order to decide a case of first impression, as you mentioned, and first impression, as you defined it, it's new law, something new, and I would imagine that the justices have different backgrounds and different.
We do, and that's a good thing. Up until recently, we now have 3 new justices on the court, and there will be 2 new justices by this time next year. I will be retiring, and 1 other justice will be retiring. But in the 2 years that I've been on the court, I don't sense that politics is an issue that any of us are concerned about, because in the majority of our cases, we are unanimous in our decisions. And every now and then there will be a dissent about one issue or another, but for the most part, we're not divided by politics, and we have a diverse group of people on the court. There are presently 4 women on the court, 2 of whom are African American. That's unusual. That's quite, excuse me, extraordinary. And I don't know what the mix will be when 2 more people retire, but at this point, all of the justices are former Superior Court judges, although that's not a requirement for the job. I do think that when the governor is making this appointment, he's looking for people who have trial experience and experience that's deep and wide because of the variety of issues that come before the court.
There are 2 topics that we would like to address, Your Honor. One being, how do justices get appointed to the Supreme Judicial Court?
Okay.
But the other one being what you just talked about in terms of deciding the case, given that 7 people will hear the same issue and with diverse opinions. Does it have to be unanimity? You mentioned there are dissents. Why don't, would you comment about the process?
Well, I think I should have answered that because I think that was what you asked me already.
Okay.
We need 4 people to agree on a particular result. As I said, though, more often than not, we have unanimity. And the way we do that is when we hear the cases, everybody has already read all of the briefs and familiarized themselves with the cases before we hear anything from the lawyers. We know what the case is about. The lawyers come, they have their argument. Each side will get 15 minutes to tell us what we need to know about the case that isn't in the briefs that they filed. And when the hearing is over, we go to a beautiful room that's called our Consultation Room, and the 7 of us sit together and everybody expresses an opinion about how they think the case should go. And sometimes we go around 2 or 3 times to get people's input. And ultimately, the Chief Justice will assign a justice to write the opinion. That's how that gets done. The Chief Justice, that's his prerogative to decide who will write, and it will always be somebody who is in the majority who will write the opinion for the court. Once the opinion is written, it's circulated to all of the justices, and we meet again in that beautiful room, and everybody by then has read whatever the justice who was responsible for drafting that opinion has written, and we talk about it. We say we disagree with this, we agree with that, and it's a collaborative process. There's one judge's name at the top of the decision, but it's a collaborative effort because all 7 have participated in some way in deciding how the issues are going to be disposed and how you're going to say what's being said in the opinion. That's very important as well.
That's extremely important and interesting, Your Honor. And what is the process for a judge to be appointed justice?
That, it's a gubernatorial nomination, and typically what has happened is every governor that I can recall has established a nominating commission whose task it is to recruit candidates to apply for the court. They interview, they review the application, which is very detailed. They want to know everything. How many cases you've tried, whether you've ever been complained against with the Board of Bar Overseers, whether you've ever been sued. They want your financial information, and they vet you for competence and integrity. And they make recommendations to the governor. Typically, for each seat, there will be 3 or more persons that this commission will send to the governor. And the governor interviews who he wants to interview. I say he because we haven't had a female governor yet to do that. And the governor makes what we call a nomination because it's not official, or I should say, you are not officially a justice unless your nomination is approved by a majority of the executive council. Some people refer to it as the governor's council. So each nominee has to go before the council, present himself or herself, and the council gets a vote.
Today, we are learning about the Massachusetts Supreme Judicial Court with our esteemed and honorable Justice Geraldine Hines. And Justice Hines has been a justice of the Supreme Judicial Court for the past 2 years.
Right.
Your Honor, I wanted to ask you, what other activities do justices of the Supreme Judicial Court get involved with?
Yeah, I think people would be really surprised if they knew the range of responsibilities of the justices. I mean, you think you're an appellate judge and your job is to listen to arguments and to write decisions, but our brief is much broader than that. The court has general superintendent's powers over the trial courts, and so every justice has some responsibility in that regard outside of sitting and hearing cases and writing opinions. We have an Access to Justice Commission, we have a pro bono committee, we have rules committee, we have the Commission on Judicial Conduct. I mean, we're not members of that, but everything that touches the courts, we are responsible for making sure that that runs properly, fairly, and all of the justices are involved in that one way or the other. I am co-chair of the Access to Justice Commission, and that's a commission that's been around for, we're going into our third iteration now. And our concern is making sure that people who don't have access to attorneys can get the kind of help that they need in our courts, trying to figure out ways of delivering justice more quickly, more fair. So we have our hands in a lot of different things, enough to keep us really, really busy. And things like this, we do, because we see it as part of our responsibility is to help the public know about what we do, because I think it's really important for the public to understand the job that we do, because from time to time, we make decisions that people don't agree with, and sometimes that's because they don't understand what it is that we're supposed to do, or how we're supposed to take care of the rights of our citizens. I mean, we've taken an oath to follow the Constitution, and that's what we do. We don't have an opinion poll to tell us what a popular position is on a particular issue. All we care about is what does the law say about this, and sometimes people understand it and sometimes they don't. So this is part of what we do to try to help people have a clearer picture of what it is that we do.
And we are grateful, Your Honor, of your time. Your colleague, Chief Justice Gans, is also a member of your committee.
Right.
What are some of your committees? What are you most proud of?
Well, I like the work that I'm doing with the Access to Justice Commission because it brings me full circle. When I first came to Boston 45 years ago as a new lawyer, I was a legal services lawyer. I came here to provide legal assistance to the poor. And over a long career doing various things, private law practice, public defender's office, Superior Court judge for 12 years before I went on the appeals court. I feel like I'm back to where I started, and I feel very connected to that work, very interested in how we're going to deal with this problem of helping people who can't afford lawyers get access to the courts. And so I'm just thrilled that I have the opportunity to do that.
And Your Honor, we do have 5 minutes left, but I wanted to ask you about privacy. It's a very popular topic. What are your thoughts and comments from the bench?
Well, I can just tell you that privacy issues are becoming very important in our courts now. The Supreme Court of the United States just decided a major case recently that involved cell phones. And in that case, the court recognizes that cell phones are reflections of what matter to people, their private documents, their family photos, their bank records. And so I think the law is having a hard time catching up with where technology is taking us. And we're seeing cases involving cell phone searches, computer searches. And so the challenge for the courts is to try to accommodate these privacy concerns at the same time that we give law enforcement leeway to do what they do. And it's a difficult balance, but we're very aware of the privacy issues, and we're concerned about it, and we take that into account, what's happening out there in the real world, social media, child pornography cases that may involve computer searches, and do people expect that whatever is on their computer is going to be searched by the police? Do you anticipate that your emails are going to be read by the government? I mean, these are things that courts are grappling with now. And, you have to know that the founding fathers of the Constitution had no idea that this would become an issue. So we're having to interpret our Constitution in a way that fits what's going on today. And the privacy area is one in which we're working very hard at that.
It's fascinating, Your Honor. You are most interesting. And I would like for you to please talk about recent cases that you feel are salient.
Well, I guess I could say that every case we decide is important, but you may have heard about Annie Dukin, the drug lab analyst, and so our court took that on to try to decide what's a fair way to resolve all of the cases that Annie Dukin was involved in. I see. So, I mean, that issue hasn't been resolved fully, but that's the kind of thing that the court is involved in. I mean, it's our responsibility to make sure that the defendants who are caught up in that are treated fairly, and that's what we're doing.
And Your Honor, unfortunately, we ran out of time, but we would love to extend an invitation so you could talk to us about the most important cases, the salient cases that we couldn't complete today. But thank you for your time, Your Honor.
I'm honored to be here. Thank you.
And for all our viewers, we were listening and learning from Justice Geraldine Hines, Massachusetts Supreme Judicial Court judge. We were unable to talk about the most recent important cases, but you can view this episode at www.discoveringthelaw.com. My name is Lucy Rivera, and thank you for watching.